going on? How's everyone doing?
Shout out to Colin. Everybody else who's cool with Colin.
Chunky! I didn't say.
Get your popcorn and your Coca-Cola and relax.
Anyway, tell Colin I'm ready.
What's going on? This is Colin. How's everybody doing? Happy Friday. Friday night. We made it. End of the week. Hope you guys all had a great week. Hope you guys have an amazing weekend. And you know, I say this every Friday. Be safe. Don't do anything dumb. I will cover you. I will. That's not a dare. That's a promise. I will cover you. All right. And what else was I gonna say? The video of the trip is finished. The thumbnail's finished. Everything's ready to go. We just finished it too late. Heather and I put the finishing touches on it at about 5:30. Too late to put it out because that's when everyone starts to go live. So it will be out tomorrow morning. I will sneak peek it at the end of this video though. So look forward to that. Also, Cat9. Yes, I will. Definitely not Cromwell is just a nickname that Irish Demon gave me. He thought my last name was Cromwell and he called me Colin Cromwell for a long time. And when he realized that wasn't my last name, he called me Colin, definitely not Cromwell. So I changed my name to be funny and I just never changed it back. So there's the story. They're a little bit longer, but that's a short version. Okay, you guys ready to watch some court? Let's watch some court. Before I hit that play button, let's go.
This is Sanctions Court hearing in cause number CR 15463, State versus Mark Lemon. Mr. Lemon, this is your first time in Sanctions Court, correct?
Yeah.
You know what Sanctions Court is about?
No.
Sanctions Court is an intervention program created by this court to try to get the attention of people who are on probation to prevent them from going to prison. People like you.
Yeah, don't want to.
People like you who walk into my courtroom positive for methamphetamine. So the probation office is well within their rights to go and ask these prosecutors to file a motion to revoke, ask me to sign that, issue a warrant for you, put you in custody today.
Dang, girl, you looking pretty cute. I'd definitely pick you in Duck Duck Goose. I would. Hi, Heather.
Take you over to jail, give you an opportunity to have an attorney, come back, have a hearing, and determine whether or not you're on deferred for a first-degree felony, manufacture, delivery, minimum 5, maximum 99 or life. And they could argue that you violated. They can argue that your probation should be revoked. You should be sentenced to prison. They're all within their rights under the law to do that. But the sanctions program is an attempt by this court to get the attention of people like you to determine whether or not we really need to take you out of society and put you in a cage. That's what we're trying to decide. Okay. So when I get a note that says you're being supervised in Travis County and you're not submitting to UAs, hang on, that you left the lab, you're not working your community service, things of that nature, that tells me that you're not. Hang on. So here's a problem. You're not listening to what I'm saying. You're still not listening. You're shaking your head. You're looking off, and all you're thinking about is the first thing you're going to say when I quit talking, and that's a problem. That's a problem because I hold the keys as to whether you do 9 days in jail as a sanction for your methamphetamine, or I say, you know what, this guy is not ready for community supervision. Go file a motion to revoke, or you to sit there. I'll sign the warrant. I'll have these officers take you into custody. That's where you're at right now. So before you say another word, before you think about another word, I want you to really think about, is it worth it? Okay. I'm just telling you what, I'm going to give you a chance to be heard. Okay. I'm going to give you a chance to be heard, but I need you to listen to me first, because the things that I'm telling you are important for you to know.
Yeah, most people use sunblock for that. I don't submit to UV either. Sunblock, suntan lotion, right, Heather? Heather's got my back. She tells me to wear it every single time I go outside.
We understand each other now? Yes. Okay. That's what's being reported to me. And then when you show up here and I'm getting ready to have a hearing and I UA you and you're doing methamphetamine while you're on probation, that's already not starting on the right foot. So you need to know what your future holds. You understand?
Yes.
What is it that you want to say that's so compelling?
I don't have anything to say.
Well, no, you wanted to say something. Now is your opportunity. Say it.
Mm,
Don't tell me, oh, I am working probation. I
no,
am doing my
I went
community
to take
service.
the UA in Travis County, and what happened was I couldn't pee at the time, and he said he was gonna mark it down as a fail. So I said, okay, I guess that's what you're gonna do, and that's what he did. They didn't ask me to stay there or anything, so
Would you have been hot? Honestly, would you have been hot?
I
Probably,
might have.
yeah.
I probably would have been.
So you're arguing a point that
How
makes
about-
no sense. I mean, you're
I'm
probably hot. I mean, you're hot now, so it's kind of moot. But I understand what you're saying. I understand what you're saying. But if they tell you, hey, you got to give a drug test, and they give you opportunity, they give you time. If you don't do it, they're not going to wait on you forever. They're gonna deem it as a positive and move on because that's what they have to do.
Biggin, thank you so much, buddy. I was in your video. You get the craziest clips, man. You really do. And every time, and I say this in the chat all the time, headphone check. If you live in an apartment and you're watching Biggin's channel, there's a lot of yelling. Just be careful. Wear your headphones. Very entertaining though, and generally pretty funny. Biggin, thank you so much for the raid. Thanks, buddy. I appreciate it. Go check out his channel. Can one of my mods please drop his link? All right, let's go.
But it doesn't change the fact that you're hot today.
Yeah, it doesn't.
Yeah. So you got a drug problem.
Try and take care of them.
So we need to figure out, A, are you going to get help while you're free? Or B, are you going to get help while you're in custody? That's what we need to figure out.
A sounds better.
Yeah, B sounds better, but I don't know that you can handle B. Well, B is custody.
No, A's. Yeah, you said. Yeah, A's.
A while you're free,
and
B is while you're in custody. So I don't know if you can handle A. We're going to find out. Can you handle A?
you can. Yes.
So what's your plan?
Dude can't handle letters. We already found out he can't handle UV. How is he going to handle A or B? Just saying. Letters are not his strong point.
To get help, more help than I already have.
Right. I mean, saying it is one thing, but I'm saying,
Doing it is another.
what's your plan? How are you going to get help?
Jeez.
If you don't know, the first place you need to start is your probation officer.
Okay.
It's the first place you need to start. People oftentimes view their probation officers as their enemy, when in fact, it's quite the opposite. Probation officers are there to help you comply, give you access to resources, tell you what you can do, whether it's Narcotics Anonymous, whether it's counseling, inpatient, outpatient, things like that. You got to talk to them and you got to let them know you're struggling. The worst thing you can do is try to hide your drug problem and try to hide your positive test and drug usage and hope not to get caught. That's the worst thing you can do.
Thanks, Biggin. Sure do appreciate it. Still working on that accent, though.
That's not addressing the problem.
Right.
Understand?
Yes.
All right. So this is what we're going to do, Mark. I'm going to reset you for another sanctions court hearing. Where do you live?
Austin.
You live in Austin. So you have to come up here.
Yes.
You know, Mark, I just remembered who you are. I just remembered who you are. It's taken me a minute.
It's been 5 years.
Yeah, it's been a long time. And let me tell you the reason that I now know who you are. You were the first defendant that came in here while I became a judge on January 1st of 2019.
Yeah. Judge knows who you are from when he was a prosecutor. He's about to say that. I just spoiled, but only for about 10 seconds. Not a good sign. Not a good sign. And just wait till you hear why he remembers him. Oh, I guess he already started.
And when I sat down there at that table, I had a policy that said no probation for drug dealers. And you were arrested, I think, over in Grand Saline.
Yeah.
And you had a large amount of methamphetamine.
Yes.
Just listen, yeah, large amount of methamphetamine. And you were charged with manufactured delivery based on the quantity. We had a hearing, and the prosecutor stood up and they argued that they have a policy that they don't give probation to drug dealers, knowing that that was the policy that I'd instituted in that office and that they were following the same policy, expected me to follow suit. But your attorney stood up and argued, heard about your daughter, I believe. You were working in HVAC, installer down, and
Also,
character, it was 5 years ago. Character references for you. And I said, but the first time as a judge, I realized that I wore a different hat than when I sat over there. And that policies are not, always one fits all. And I looked at you as an individual and I decided, you know what, I'm not going to follow that same policy. And I went against conventional policy and wisdom. And I said, no, I'm going to give him a chance. And I'll tell you, Mark, I've been bragging on you prior to this day. I've been bragging on you because I said it taught me a lesson that there's individuals that can defy the norm and they can change. And I bragged about you. Here we are.
Ah. The judge used you as a reason to brag because he thought he helped you, and you're right back in the same position. I would be, kissing the judge's ass right now. I would be saying, I'm so sorry. I would be doing whatever it took to try to get on his good side right now. This judge doesn't get mad. This is as angry as you'll ever see this judge. And this is his disappointed face right here. And you can hear it in his voice.
Now, I'm not saying that I made the wrong decision. And I'm not saying that you screwed everything up and that you take that story away. I'm not saying that at all. I'm just saying I'm disappointed. Because I did remember you. So what we're going to do to get you back to where you were? That's the question that I'm posing, and that's what I've got to figure out. And let me tell you what I'm going to do. I'm going to do the only thing I know to do, and that's to give you time to show me that you can remain on probation, that you can do what you say that you're going to do. I ordered you to do 500 hours of community service back on April 15th of 2019, and you've done 10 in 5 years. So just listen, you've done 10 in 5 years.
Okay, so on the screen on the bottom, so there's three screens, right? Top left is judge, top right is the prosecuting table on the right, the public defender on the left. I think the public defender is his. I'm not exactly sure though. Because this is just a sanction. He's on probation, and this is a sanction. So his lawyer probably is no longer representing him, and he's here just because he failed his probation. So he may actually have to ask for a lawyer. He might not be represented in this hearing. I'm not sure. I don't think a lawyer says anything. The defendant is actually at the bottom screen, but the camera is, for whatever reason, focused to the left. So every once in a while you'll see him kind of bounce back a little bit. He doesn't sit still. So you'll see him a little bit on the right hand part of the bottom screen, but yeah, okay. Now that we know the setting, let's finish this up.
It's a problem. You're supposed to expire in April of 2029, so you still got 5 years to go, so that you have plenty of time to right the ship before it sinks. And when the ship sinks, you go down with it. Anybody else you got on your ship, significant other. You have a daughter, right? How many?
Oh, I have 5 total.
Five.
But, 2 live in Houston, 2 I've never seen, and I got an 18-month-old.
So there's people that are on your ship.
Yeah, and I got married 1, 2, 3, 1, 2, 3.
So there's a lot of people on your ship. So if your ship goes down, they're either going to drown with you or they're going to have to abandon ship and go to someone else's ship.
All right, I'm just gonna say this. For people that get married on a specific date just to get married on a date, that's fine. You do you. You know, I understand. You know, the idea of 1 2 3 1 2 3, but after that day, I wouldn't say I got married on 1 2 3 1 2 3. I would say I got married on, what is that? It's December 1 2 3 1 December 30. He got married on New Year's Eve. That's such a much cooler day to say. I got married New Year's Eve a year ago. No, it wasn't even a year ago. It was 4 months ago. I think that's so much cooler than saying I got married 1 2 3 1 2 3. You guys can disagree with me if you want, but yeah. Anyways, let's go.
Correct?
Correct.
You're the captain of your ship. It's not me. It's not me. I really don't decide where your ship goes. You do. Your actions, right? I'm going to bring you back. I'm going to reset you for Tuesday, May 28th. I'm gonna tell you that these are things that you have to accomplish before May 28th so that I can try to right your ship. Okay? These are things that have to be done. If you don't do them, then it's just going to create more consequences for you. Okay? You're going to have to pay $100 to the probation office for your fees. You're going to have to pay $150. We're writing this down for you. $150 towards your court costs. You're going to have to work 10 hours community service. That's the same amount that you've already worked in 5 years. You're going to have to find a weekend. You're going to get that done. If you don't work on the weekend, if you work on the weekends and not during the week, or you're in Travis County in Austin, I'm sure there's things that you can do at night. You just got to find out where you can go to your probation officer, find out which areas are approved for that. Don't go out and volunteer somewhere and expect it to be approved. Doesn't work like that.
Yeah.
Go to the approved list. I need you to attend your you know what your IOP?
Yeah.
What's that?
That's intensive outpatient.
Okay. I need you to attend that. I was set on giving you 9 days in jail as a condition, as a sanction for being hot for methamphetamine today. But I tell you what, I'm not going to do that. I'm not going to do that. Rather, the probation office is going to save that as a violation. And if down the road you don't do what you're supposed to, then they're going to give that information to the state of Texas and they're going to use that against you in court. So that you know, it doesn't mean that you've done methamphetamine, you've been caught, and it doesn't matter. It means that it's deferred right now. We're going to put that out in the future. If you do what you're supposed to, that's not going to come back to hurt you. If you don't do what you're supposed to, it's going to be something that your defense attorney is going to have to defend against. Does that make sense?
Yes.
All of these things have to be done, completed.
Yeah, it kind of does. It just needs a little bit more stained glass. If there was stained glass, then yeah, I would absolutely see that. This does kind of look like it would be a church. Also, too few doors. They need a couple more doors. And then yes, absolutely.
And reported to the probation office before noon on Friday, before you come back to court. The Friday of the week before you come to court. All right, Mark, go ahead and sign that notice form, and we're going to see you back on May 28th.
Yep. Judge gave him another shot. he might have a soft spot for him, just like he said, he created a whole policy for that guy. Bragged on him, he gave him another shot, even though he tested positive. All right. Well, we'll see. He comes back in a month. We'll see how he does. All right. All right, let's go. I'm debating. Do I sneak peek the trip video now? No, we'll wait a little bit.
With
I guess I should say, for everyone who missed the intro, I have the court crawl video completed. I just completed it too late to put it out tonight, so I'm gonna do it first thing in the morning, and I'm gonna sneak peek a little bit of it tonight. So stay tuned for that.
Miss Calvillo, come on up.
Morning.
Morning. How are you today?
I'll be better when I get to go home.
I understand that. Okay, your time served on your capias, so we're not going to talk about that. Let me just mark that.
Somebody said there's a KC. Donald, was there a KCC raid, or did you just come over from KCC? I don't know. But because I don't get the notifications on this side, so I just wait for everyone to say something. So KCC, if you did raid me, thank you so much. I appreciate it.
Then on August 28th of 2023.
Yeah, that's what I kind of thought. But you know what? Anyways, KCC, thank you.
You had a citation for operating an unregistered motor vehicle and driving without insurance. How do you want to handle those? Do you want to plead not guilty, no contest, or guilty?
What do I do? I mean, I'm a little bit confused here. What do I plead if I want to because these are the ones that I haven't went to court, right? That I still have to plea out on?
Yeah, you haven't I've never seen you on these.
Okay, so no contest, I guess, until I see you in court, or what?
No, that'd be a not guilty.
Okay, no, then I guess guilty. Then I see you at court.
What are you trying to do?
I'm a little bit confused. Okay, I want to.
Okay, let's back up.
Okay.
On August 28, 2023, you received a citation for operating an unregistered motor vehicle, some 2006 Chevy Monte Carlo.
Okay.
You also were driving without insurance, allegedly. This is over on West Chaparral Road. Okay?
Okay.
If you want to plead guilty.
Yeah, this is actually one time where I honestly think that she's not acting. I think she's completely clueless. And that's why I put this in here. It's kind of funny, kind of sad. Also, the guys behind her try to help her out. They get yelled at by the judge. It ends up kind of being an interesting case, but it's very simple. Very simple. It should take 30 seconds, and it somehow ends up taking 5 minutes. Kathy, thank you so much. 5 get the membership. Kathy Berry, thank you. I appreciate it. And welcome to all the new members. We're only, 3 days away from Members Monday? Oh, excuse me. Hiccups all of a sudden. 3 days away from Members Monday. Thank you, Kathy. I appreciate it.
To your no contest, I'll find you guilty. I'll assess your fines and court cost. One of them's $242, the other's $400. Your time served on those. Okay? Or you can plead not guilty. Come in, talk to me, see if you want to set those cases for trial or hire a lawyer. You have those rights. So you can plead not guilty, and I'll set a bond. You come in, you talk to me. We'll set you up to file motion for discovery. Give you time to go hire the lawyer, whatever you want to do.
So, and then if I plead guilty, what happens?
Your time served.
Okay, then yeah, guilty.
You will have convictions. You'll have a conviction for operating an unregistered motor vehicle.
Okay, that's fine.
No insurance. Okay.
That's fine.
You've had previous convictions for no insurance, so understand that this one will likely cause your driver's license to be suspended, okay?
Okay, so what do I need to do to fix that?
That's between you and the Department of Public Safety.
Okay.
They're probably going to make you get SR22 insurance if I had to guess. Now, on April 17th, the day you were arrested on higher charges, you also received a charge for possession of drug paraphernalia.
Yes.
You may plead not guilty, no contest, or guilty to that. What do you want to do?
No contest.
If you
Well,
plead- If you plead no contest, I will find you guilty. I'll assess $531 fine and court cost. I'll give you 3 days jail credit. Your balance will be $81. If you plead not guilty,
Speaking of KCC, hi friend. Hope you're doing well tonight. Hope you had a great stream. Hope you did.
I'll set a bond on your case to give you the opportunity to come back in here to court, give you time to get the lawyer hired, and file that motion for discovery.
Can one of my mods please drop KCC's link? I would appreciate it.
Both of them, unless you paid the $81.
Okay, no, I
Now,
need,
wait, let me say one more thing. One of the first things I said when I started talking to y'all was if you have higher charges connected to these cases, you need to understand that pleading guilty to these cases could affect your higher charges.
okay. So then if I put no contest. then
Don't tell her what to say.
No,
I know you understand, sir, what I'm saying, because I can tell you were nodding your head, but that wasn't the right answer, okay? You're not a lawyer. So you can plead not guilty, get a bond, come in, file a motion for discovery, take the time to hire a lawyer, figure out what's happening on your higher charge, or you can plead no contest or guilty. I will find you guilty. I will assess fines and court cost of $531. I will give you 3 days jail credit. Your balance would be $81.
So then I would, so we're doing that, then I would have to stay how long?
You don't have to stay.
Oh, I still get to go home today.
Either one, you get to go home.
Okay, the one with the $81.
Okay. So is that guilty or no contest?
No contest.
Okay, I'm super unsatisfied with your understanding with
I'm sorry.
whether or not you understand.
I'm sorry, okay.
What is your struggle?
Okay, what I want to know is, I just need to get home to my kids today.
Then
So
no, ma'am, you need to think differently. You have a higher charge in Potter
yes,
County.
ma'am. Yes, ma'am.
Listen to what I'm saying.
Yes, ma'am.
I'm going to say it for the third time.
Okay,
Pleading guilty or no contest could affect your higher or additional charge.
okay.
Okay?
Yes, ma'am.
Do you know what that means, what that sentence means?
Yes,
Okay.
Yes.
Do you still want to plead guilty and just pay the $81, or do you want to plead not guilty and set a bond? You're going to get out of jail on our charges, and I don't think you have anything else holding you in Randall.
no, ma'am, I don't.
Then you will get out of jail today, regardless of which way you plead.
So no contest. Okay.
If you plead no contest, the court will find you guilty. You'll still owe $81.
Okay,
Okay. You have to be here by Monday at 2.
okay,
Okay. If you can pay the $81, you just pay the $81.
okay, I can do that on Monday, right?
You can, here's the deal. The nice deputy in the back is going to give you a piece of paper with directions to the municipal court. Miss Calvillo, I know you know where it is. You've been here.
Yes. Yes, ma'am.
But if you don't remember, then he's going to give you that map. On that map is also a QR code where you can just use that to make that payment, or you can just use the hyperlink, or you're welcome to come into our court and make that payment. You can even come in today and do it if you wanted to. Okay?
Yes, ma'am.
Thank you.
Thank you.
You can go back to your pod.
All right, what do you guys think? You guys ready for the sneak peek of the video, or should I wait a little longer? We itching for it? Let's sneak peek it. Let's sneak peek it. I feel like it. I feel like it. Got my black and white intro.
What's going on? How's everyone doing?
A shout out to Colin. Everybody else who's cool.
Chunky, I didn't say.
Get your popcorn and your Coca-Cola and relax.
Anyway, tell Colin. I'm ready.
What's going on? This is Colin. How's everybody doing? I know camera's a little blurry right now. It's dark, so this is the best I got. It is 4:10 right now, and I am leaving. Gonna go pick up Sly. Let's go. What's going on? This is Colin.
This is Sly.
We just met up. We're in Findlay, Ohio, and now we're headed to Detroit.
Up to the Motor City.
Let's go.
Let's go.
All right, we made it. All right, we're gonna fast forward a little bit. We're gonna go to Judge Slavin's part. Here we go.
Docket. So we're just hanging out with them. Just walking around the courtroom. You guys want to check it out? You know, got our classic church pews. All right.
But
You know, simple tables. It's a nice courtroom. I like it. Man, what do you guys always see? Well, besides these weird people.
you know what? I should have brought the popcorn and the Coke so I could.
Put your popcorn and your Coca-Cola and relax.
Proper host. Yeah, you got the proper host here.
All right, here we go.
How you doing, neighbor?
All right, that was fun, right? That was fun. There's your sneak peek. There's your sneak peek. Yeah, and yes, whoever said I think I was itching to play it, I am. I am itching to release this so bad. I spent longer on this video than I have on anything else so far on my channel, and I'm really excited to release it. So yeah, that's a little bit of the middle. Okay, now let's go back to our regular schedule program. Like I said, I will be releasing that in the morning. I don't know what time yet, but it's probably gonna be 8, 9 a.m. somewhere around there.
2405-670801 for the state of Michigan versus Zachary Taylor. Defendant is charged in count 1, assault with intent to do great bodily harm, less than murder by strangulation. Count 2, domestic violence. Defendant has a habitual offender, fourth offense notice, mandatory 25-year sentence.
Appearances for the record, please.
Good morning, Your Honor. Shelley Drain for the people, P number 60249.
And Judge, good morning, Mayor. Please, this most honorable court, Benson J. Toussaint, 58609, on behalf of Mr. Zachary Taylor, who appears today by Zoom, consents to having his hearing heard by Zoom today.
Tell us your name for the record, Mr. Taylor.
Zachary Taylor.
What's your pleasure, Mr. Toussaint?
Your Honor, at this point in time, we'll set this for a preliminary examination.
House April 24th at 10:30.
April 24th at 10:30. Judge, I'll make that work. If I have any problems, I will contact the court.
All right. April 24th at 10:30. Bond will be continued. Thank you.
Judge, as the bond,
Yes, sir.
my client has a teller and a curfew. I know that he has no criminal history that is assaultive in nature. He has a job. This is with a person who he lived with a number of years. He has not returned to the residence. He will not return to the residence, nor have any contact with her during the pendency of this case. He has no capious history. He has retained counsel. We're requesting that at least the provision for the home confinement be lifted.
So he's on house arrest?
He's on house arrest, Judge.
No provision for him to go to work? Where do you work, sir?
I work for ZS Investments,
How long have you worked there?
6 years.
Ms. Green?
Your Honor, I am not objecting to a modification of the tether, which would allow Mr. Taylor to be able to go to and from work upon receipt of verification of employment.
So I'm looking at the arraignment form here. It says that a GPS tether 9 p.m. to 6 a.m. curfew. He's not on house arrest.
I think Judge, when we have a GPS, we want to know where the individual is. And I think that is sufficient for this court to know that he's not having any contact with the complainant. But to have an individual on house arrest or any type of
house arrest.
Well, any type of eviction, Judge, I would think that you have to have an individual in the house. But that's I think that's confinement.
No, that's not the same as house arrest, Mr. Toussaint. House arrest is the jail is your house and you're not able to leave it at all. What time do you work, Mr. Taylor?
I've been working midnights lately.
And you work for who?
ZST Investments.
What investment company works at midnight, sir?
You can already see Judge King's wheels are turning. He's like, I don't believe this guy at all. Just wait. Just wait. I don't want to pause it again, but it's about to go down. Probably a minute or two before it does, but just be ready.
I look at properties and work and do home improvement all day.
At night, midnight? I don't think so.
Not midnight. Some nights I work nights. Sometimes I do.
Sound kind of fishy to me, Mr. Toussaint.
Judge, we'll give verification, but it is nighttime, Judge. If this court were just to put it from midnight until 6 a.m., that's fine. But just to have him come in from 9 o'clock to 6 a.m., I just don't think that's.
Who's your supervisor, sir?
Shinetta Coleman.
Phone number?
313.
This is when he realized he fucked up. Just gave his supervisor's phone number, and Judge is like, I don't buy this story at all. Picks up the phone. What do you guys think? Telling the truth? Nah, he's not. He's not. Everyone knows he's lying. Oh, that might actually work too. Just wait till you find out who it is, whose number he just gave. It would have worked. Judge King called. He picked up the phone and was dialing. It wouldn't have worked. It's too late for that.
Hey, Shelly, could you give me the discovery?
Yep, I'll send it to you today.
All right, thanks, Shelly.
Sure.
Judge King is enjoying this phone call. How is this phone call this long? I don't remember it being this long. This is kind of funny. I wish we could hear what he was saying. Yeah, it's literally like, this is new. Judges don't do this. Yeah, Judge King doesn't play. Does not play. He sees bad people all day long. He does not play games. Alleged bad people.
Okay, Mr. Toussaint, he's lucky I won't revoke his bond for lying to him. First of all, that's not a supervisor name he gave me. That was his daughter's name. Secondly, his hours vary from 8 a.m. to 8 p.m. What's this midnight stuff? I have no idea.
I think
So he's fortunate that I'll continue his bond and not revoke it at this time. Too early to be lied to in the morning.
Thank you, Your Honor.
Thank you.
Yeah, I think his daughter may have said something that changed his mind. I don't know why, or yeah, Judge King was convinced at that point this guy's lying to me. He's absolutely lying to me, and didn't revoke his bond, but he was busted. That's going in the notes. Just wait till you go to your hearing, buddy. All right, next one. Let's go. Next one.
Afternoon yet. Good morning.
All right, this one's a little strange. This is an illegal tow. I've got 2 illegal tow clips in this video. Tow clips? Yeah, that sounds weird to say that. Yeah, this one's a little weird, but you'll see why I put it in. And it has nothing to do with the defendant. Everyone, please be nice. Please be nice.
Morning. I'm Judge Meeker. I'm sitting in for Judge Holmes, and we have a tow hearing scheduled. Kirsten.
Just correction. This isn't a defendant. You know what? She's the one who, the person at the bottom is the one who is suing the tow company. So does that make her the plaintiff? I think it makes her the plaintiff. All right, let's go.
Lockhart is here, and who's here on behalf of the towing company?
Your Honor, it's Fabio da Silva. And also, if Austin Police doesn't show up because they get shorthanded, as a contractor for them, I represent APD as well.
2018 you can tell us what happened. You know the facts of the case. You'd have to file a different kind of lawsuit.
That didn't happen. Nobody saw that. Nobody saw that. And it's impossible to rewind, right? It's because this is live. That's how that works.
If you're asking for damages. Okay.
Okay, then let's stick to the tow charge.
Yeah.
Can the tow Fabio represent APD?
Pardon me?
Can the tow driver represent APD if he doesn't work for them?
Well, if he knows, all we need is the reason for the tow, why APD needed to call for the tow. And if he knows that, then that's all the information we need. Did they tell you why they towed it?
Not really.
Not really? Okay. And you paid $420.66?
Yes, it says so on the form. Don't remember the number offhand, but that sounds
close to it. Okay.
I mean, I'm sure I put the right number down, but I just don't remember it down to the cents.
Okay. Well, they can confirm that too. Okay. Oh, let's see. Mr. Da Silva,
Yes, Your Honor.
Can you tell us what happened with his tow?
Yes, Your Honor. So basically, this boat was on a trailer on a public street within the city limits of Austin, unattached to a truck. It becomes a city ordinance violation. I send in some exhibits with the state law. Our exhibit number 1.
Okay, hold on. You sent some exhibits in?
Yes, Your Honor, I did.
When did you do that?
I confirmed with Brochet that she had it yesterday.
Okay, Brochet?
Your Honor, give me 1 second. I'll pull it up here.
Yeah, because I don't see anything in what I see in the case.
Yeah, again, let's be nice. Let's be nice. She filed a lawsuit. She came to court, and she's, trying to prove that she should win this lawsuit. And yes, it's about a towing of a boat. So all the facts behind this are kind of funny, which is why this is in here. But yes, let's be nice to the people in court, please.
Because I looked for stuff.
Okay, give me one. So, Your Honor, if you go to the documents,
Okay.
yeah, it looks like I need to add the actual event, but for the documents, it's going to be exhibits 1 through 5 right there.
Oh, okay. I'll just go to documents then.
Yes, ma'am. Let me update
Okay.
that.
It says no work. Okay, I'm in documents. I'm going to documents. Here we go. Okay. Exhibits, is that what it is?
Yes, sir.
Yeah. Yes, Your Honor. 1 through 5.
Okay. Oh, that's just one. Okay.
Yeah, that's just one. I have one. One is the
One's
city
by
ordinance.
itself, and then the other one should be 2 through 5.
Okay, 1 of 4. Oh, I see what you're saying. Okay, I've got the pictures now.
Yes, ma'am.
I see. So it's an ordinance violation.
Yeah, no, that's exactly what happened. That's exactly what happened. And she's fighting it.
Violation to park like a boat or a trailer that's unattached to a car on a city curb.
That is correct, Your Honor.
Okay.
So that's why the Austin police officer picked it up, because it was unattached to a vehicle.
Right.
And there's an apartment complex right adjacent to it. There's houses, but it's it's just a city ordinance, just to keep it simple.
Right. Right.
I exhibit 2. Let me know when you're able to get to that.
Okay.
It just says it's a tow slip from the Austin Police Department to the tow company authorizing the tow. And it says illegally parked. I highlighted some things so that to try to make it easier.
Yeah, I see that. Okay. Yeah.
And then exhibits 3 to.
Thank you, Julie. I appreciate it. Welcome to all the new members, and thank you, Julie, for the 5 gifted memberships. I very much appreciate it. Thank you so much.
5 are just how the boat and the trailer were parked
Right.
at the scene. Those are scene photos.
Yeah. So it was clearly parked by the curb there.
Correct.
Okay.
And that's all we have, Your Honor. It's real simple.
Sure.
We don't have much more to testify on, except that it was a city ordinance violation. It was picked up. And then as far as the cost of the tow, it racks up every day, $22.85 until the person picks it up. Shouldn't pick it up right away. That's why it became that amount.
So
and
the 420.66, is that the correct amount?
Yes, it is.
Okay. All right. Okay. Anything else, Mr. De Silva?
No, Your Honor, that's it.
Okay.
You'll find out. She'll say. She's intelligent. She cites ordinances and she tries. She really does try. But you'll hear. You'll hear why she's suing.
Okay. Ms. Lockhart, do you have anything else to say? Now that they explained why it was towed?
So basically, maybe it's a violation. Look, first of all, I didn't see the exhibits. I don't know if that was meant that way or not. Maybe only you were supposed to see them, but.
Do you want, Rashay, could you put those exhibits up on the screen?
Yes.
All right. I don't think there's any personal information in these, but if I see any numbers of any kind when these come up, I am skipping ahead. I'm sorry. But I did mean to double check these before I put this up. And yeah, as always, my editing sucks.
Yes, ma'am. Give me
The
one
photographs?
second. For sure. 1 second.
Yeah, we're gonna screen share with you, Miss Lockhart.
Okay.
So you
Give
can
me
see
1
the
second
pictures.
here.
Yeah, Brachet's gonna do that so you can see just exactly what the photographs show.
Give me 1 second. I'm opening them all up here.
Yeah, just the photographs is what we want. Okay,
Maybe an unattached trailer is a parking violation, but is that one of those? But I thought it doesn't require towing, just a ticket. Some parking
Well, it-
violations do require towing, like if you're by a fire hydrant or in a handicapped spot, but this
it's
one,
up, it's
one
up
is
to
this
the
one.
officer's discretion. That's the officer's discretion.
What statute did they use to tow it?
Pardon me?
What was the statute authorizing the tow?
What's officer's discretion? If something is illegally parked, then the officer can decide whether to ticket or to tow.
Could I see the statute authorizing officer's discretion? Because
No, we're not here to show you, we're not here to show you statutes, Ms. Lockhart. We're just
Then could
saying
you
that
cite
that
the
was in
statute?
violation of in violation of a city ordinance, and so it was subject to being towed then, okay? If you violate a city parking statute, then you run the risk of getting a ticket and getting the vehicle towed. That's the way the law works.
But then don't I have a chance to appeal the ticket?
Or you could always appeal the ticket the ticket is separate from the tow. A ticket would be a parking offense, and if you don't plead guilty, you have the right to a hearing on that, and if you're found guilty, you can appeal that. This is just the administrative hearing on the towing charge.
Because I thought I thought there was a statute clearly saying which parking violations result in a tow. And there's not as much latitude as some people think.
Well, with regard to the tow hearing, if I find probable cause that that supported the tow, then the money is not given back. If I find that there was not probable cause to tow the vehicle, then the money does not go back. That's the only issue I look at in these hearings is probable cause. If probable cause supports the tow, then you can't get the money back. And they just have to show that there was a violation of a statute that subjected it to being towed.
That subjected it to being towed, right? So because not all violations are subject to being towed. Maybe almost all violations are subject to a ticket, but only some of them are subject to an immediate tow.
Right, it's got to be in violation of a statute, in violation of a parking statute.
To get a ticket, yes. Get towed, doesn't it require a little more?
No. And probable cause is a very low standard as it is.
Yeah, Peeps, you're right. When you appeal, you have to pay the bond, which is the amount of the ticket. So, but if you win, you get that bond back. So if you think you have a case and you strongly believe that the judge did not make the right ruling, then yeah, you can absolutely appeal it, pay the bond, which is the ticket price, and hope you win on appeal, and then you get that money back.
Okay.
What's the statute authorizing the tow? Could you cite it so I could look it up?
The city ordinance that prohibits someone from parking a trailer on the street without having the trailer hitched to a vehicle. That parking statute.
That authorizes the tow?
Right, that supports the tow. Okay, so I'm going to find that the plaintiff is not entitled to return of the tow fees. thank you to, we'll get the judgment out to each party. Thank you to both parties for appearing in court today. And I appreciate y'all showing up. I hope you have a pleasant rest of your day.
Thank you, Your Honor.
Take care. Y'all take care.
Thank you. Okay.
Man, that was a little. Yeah, I remember that being more exciting. Sorry. Anyways, let's move on. Let's move on. No commentary needed. What is next?
As president at the podium.
Oh, this guy's a winner. I should have waited to do my sneak peek in my video because you guys are going to need to upper after this. After that last one and this one.
Ms. Rice, you may proceed.
Your Honor, actually, we are here on, I believe, Mr. Sullivan's motion, from my understanding.
No, Ms. Rice. Earlier this week, Mr. Frank filed a motion to dismiss. He sent me an email yesterday asking if we'd be moving forward today, assuming that, given the late filing, that I would not be, and I informed him that that's correct. I'm going to need more time to file a response. I also informed Mr. Frank that at our last hearing, I had mentioned that I had requested law enforcement to get new search warrants for the phones and re-extract the cell phones. In the interim, they've done that. Earlier this week, I went over and looked through those cell phone extractions, and I yesterday filed a discovery response, and I've got extractions that I can provide to Mr. Frank. There is still one phone extraction that I cannot provide due to the on the extraction, but the other ones I have, and I've asked him to either provide me a thumb drive or let me know how he wants me to get them to him. So I've not heard back from him. So if you could let him know, just let me know how he wants me to provide those extractions, and I'll get those to him. And also reiterate to him that there is that one that he needs to view in person that he did once before, but would need to do again if he wants to look at that one.
And there has been a C4 motion filed. I'm sorry, Ms. Wright. There has been a C4 motion filed to dismiss. It was filed on the 16th. So what I'm going to do is I'll set this for the 24th to allow the state to respond.
Mr. Clark, can I say something?
Yes. You may want to check with Ms. Rice.
Ms. Rice, I want to speak and say something today. I don't never come in the courtroom and say nothing. I'm never disrespectful, but I got 1,282 days jail credit. And I don't know if Mr. Frank and my attorney is communicating with each other or what's going on. I know Mr. Frank's caseload is real heavy. He took on my case. I've had 3 prosecutors, Lexus Sykes, Jennifer Lee, and now him. I'm innocent. I mean, I understand he's got to do his job. My attorney got to do their job, but is there any way we can make this case a priority?
Mr. King, I promise you that any case over 1,000 on my docket, because I tell you one thing, who's been constant in this case?
Yes,
It's
sir.
me and you.
Yes, sir.
I guarantee you, I think about it all the time, and I know that you're on my docket. There's only so much I can do. And there's a motion to dismiss. Your attorney's done that, it's sworn to. It was only filed 3 days ago, so the state has an opportunity to reverse that. And also the state has indicated they have more evidence that your attorney needs to view. So it's a priority of mine.
All right, just real quick. I muted out the CP violation or the CP allegation that he's being charged with. So just so we're all aware, he is being charged with CP. Not going to say that out loud. I muted it, but yeah, 1,282 days is a lot of jail credit. He's most likely going to be serving more than that, though.
I understand that, sir, and they're looking into these phones. None of them are mine.
Okay.
So I understand that's not why we're here today. It's just that I don't want to put everything on Mr. Frank. I don't want to put everything on my attorney, but either way, I want this over with.
All right,
whatever we need to do.
I've got it set for that motion to dismiss on the 24th.
Your Honor, if I may address Ms. Rice, I guess to pass a message to Mr. Frank. Lately the litigation in this case has been over some maybe inconsistencies in the opinion that Mr.
All right, this is Florida, and this is the Bay County area of Florida, and CP is child. So the first word is child. The second word is, PORN. Hopefully that helps. Hopefully that doesn't get me in trouble by YouTube.
King just expressed that he's innocent of these charges. personally, my opinion is that Mr. Frank is unaware of all the evidence in this case because he's not gone through that cell phone extraction that contains the child porn. I think Mr. Frank needs to take a look at that and the evidence that's contained in that cell phone. And maybe Mr. Frank's position on some of these things would be different. So,
Your Honor,
Ms. Rice,
may I
you could pass that
respond?
along.
Yeah, yes, ma'am.
I simply want to respond. You know, Mr. Sullivan has just provided, for example, some additional information as of this morning. So Mr. Frank has gone through the information and you're still providing additional information. And so, to question whether or not we've gone through everything, everything's not
referring
been
to the-
provided yet. So.
I was referring to specifically the cell phone extraction that he did go to the Panama City Police Department and review once previously.
Okay.
That's the one I'm specifically referring to.
Okay.
The
All right.
the other ones I understand, but that specific one I think he should probably go look at a second time.
Yeah, I muted the first one where he said it nice and slow. The second time he was kind of fading out, and I missed it on my first go through. So yeah. Looks like this video is getting demonetized. All right. What was I gonna say? Oh, interesting fact, which I just found this out a couple weeks ago in Judge King's court, that prosecutors can't send, CP files to the defense for discovery, which, kind of seems bizarre, but it's technically considered distributing. So the defense actually has to go to the prosecutor's office and watch it together. Or watch it at the prosecutor's office. They can't send it because it's considered distributing. And never would have thought about that. But it makes sense. It really does. Which is why they can't give it to the defendant either. This is going to come up. The defendant doesn't really know what the prosecutor has because they can't send it to him. It's something you don't really think about, but it makes a lot of sense.
Because the evidence that I saw in that case is pretty strong.
Okay, and I appreciate you bringing up the fact that he did actually come over to view that in state attorney's presence. So to question whether or not he's gone through it, I mean, I appreciate you mentioning that.
I don't know how thoroughly, I wasn't the attorney at that time. I don't know how thoroughly he went through it at that time. I'm just saying I recommend he does it again because I don't know what he's seen and what he hasn't seen in that cell phone extraction.
All I can give is advice. I would advise.
All right. Is it? I'm Kaji. I don't want to say it's Kagi because I think that's going to be wrong. Kaji, Honoric. Anyways, thank you so much for the super chat. I appreciate it. It's generous of you. And yes, thank you. I did try. Just the whisper when he was walking away from the mic. Yeah, I missed that one. But thank you.
It may help if both Mr. Frank and Mr. Sullivan reviewed it at the same time. I've done that before.
Absolutely. And I
I
believe Ms. Lee
when
did
I
that.
practice law, but that was sometimes some of the best ways to resolve a case or resolve evidence issues of both attorneys reviewed it at the same time.
And
That's just an opinion. So I'm gonna set this for May 24th at 9 o'clock. And then that'll give the state an opportunity to reverse it. I'll give Mr. Frank an opportunity to review the new evidence he's just received this week. Okay?
Yes, Judge.
Thank you, Your Honor.
Mr. King, I am aware how much time you spent in jail. I promise you. Yes, ma'am. Ms. Rice, have a good day.
Thank you, you too.
All right. Now I think we are on the last two cases. Yeah, these are the last two cases. Man, we've already hit an hour. Am I talking that much? This might just be a long video, but I am talking a lot. I am pausing a lot. We're gonna start with the award of the night is the King Jackass. That's gonna be the first clip, and the second clip is it's another toe. It's another toe case, but we may have a male Karen. Last time I called a male Karen a Ken, I got in a lot of trouble in the comment section. So I'm just going to say male Karen to be safe. But the guy on the bottom is the male Karen. He's in the next case. But wait until you hear the award-winning Jackass of the night that we're about to hear.
Okay, is Joshua Santini present? All right, Mr. Santini, your case has been set for April 29th at 9 o'clock in the morning.
So everything is, I have a question. I'm sorry to bug. It was, I haven't been served yet from my ex. So is that?
See, everyone has a different name for him. Everyone has a different name for him. Yeah. Yeah, for the last couple of years, I called him Ken's, and that's what I've called him. And everyone knows who you're talking about. But the second I put it in the title of a video, every troll on the internet decides to jump in my channel and tell me that I'm absolutely wrong. No comment about the video, only because I called them a Ken instead of a Kevin or a Chad or whatever other 1,000 names everyone thinks that is the right one. All right, let's go.
They're both going to be heard on the same date.
And the date was?
Monday, the 29th.
Monday the 29th.
The court clerk will send you all the paperwork so that you can have her served.
In the meantime, she's harassing them, Your Honor.
Yeah, you can, if you'd like, you can just go straight to the civil counter and they'll give you your copies instead of having to get them by email.
But also, she has been calling him.
Calling my family, calling his job. So does the order go against her also to stop her from doing these things?
We don't know. We're gonna decide that on the 29th. Folks, you're not listening. You're just talking. So if you can, you can go pick up your documents at the court clerk's window.
So did I submit a response or did I submit a new petition for a protection order? Because that's what I thought I submitted.
What you did today?
I did a protection order yesterday.
Yes, that's what you did. You submitted
So
it.
you're not going to grant it. That's what you're saying.
I don't know yet. We're gonna have a hearing on that on the 29th.
I'm here today, not for a response. I have to serve her paperwork. That's what I filled out yesterday.
Yes.
What I
you
filled
have-
out yesterday
you do
was a
have to serve
protection order.
I was gonna make that same joke, but I didn't know if it would land. So thank you for doing it for me, Skizrock. I appreciate it.
Not a response. With evidence included in my protection order from my manager and my owner showing that she called the company. What happens if CPS gets called on me? I need.
You might be mixing these.
No, I'm not mixing anything. I didn't put the docket of what she had. I haven't been served from her. So I haven't responded to what she submitted. I came yesterday because you're right. I came yesterday because she texted me and said, surrender your weapons. And I came straight to the courthouse and I filled out my petition for a protection order.
Right, that's what we received.
So
and we're
I
dealing
don't get
with
one, is
today.
what you're saying?
Correct. Well, not on
Correct. On the
not on
record,
an
you just said
emergency,
correct.
not on. I'm not sure I'm following you.
I came yesterday to fill out for a protection order,
Yes.
not to respond to her paperwork. I
Correct.
have not been served yet. I have not anything yet. I still have my weapons in my house because I have not been served. I called Lacey PD and they told me, don't worry about it. She needs to figure it out and get you served. So I came yesterday for a protection order because my
I've been muted this entire time. I paused it to answer that question. I tried to answer it quickly, and now I'm paused for way too long. No, it's either Thurston County or Lacey. This is the state of Washington. All right. Now that I've paused it for way longer because I had to repeat myself, let's just go.
owner, my manager, and the company of FedEx called me and told me that they have something of a voice recording for her. I submitted the evidence, my manager's text messages.
Yeah, exactly.
So I need a protection order before she continues to try to ruin my life. She's harassing me.
You filed a petition for a protection order, which we received. I've reviewed.
And you're not
That's an
granting it.
ex parte petition. I'm not granting an emergency order, but I am setting the case for a hearing to
So
determine.
what happens if I keep being
Okay,
harassed?
That's it.
What do I do?
That's it. Just stop talking. You're not listening to what I'm telling you.
Yeah.
Stop by the clerk's window and
I'm
pick up the
listening.
documents.
I'm listening. You failed to oblige by what I submitted. What you did was think that I responded
We're
to
gonna
it, but I didn't respond.
move on with the calendar here.
I'm pretty sure you want to go have lunch, so do I. That's not what I came here for yesterday, was a response, not that.
Right, the next.
Yeah, I don't know if you could hear that. As the door was closing, he was still yelling at the judge. I mean, all right, so that's the entitled kid that thinks that, the court needs to work around his schedule and do everything he wants. All right. Anyways, Dorina, Serena, let's go. Let's hone back in. I'm not on mute. Okay, I'm not on mute. All right, good. Serena, thank you so much. Remember 3 months? That's awesome. Heck yeah. Heck yeah. Thank you so much, Serena. Also, Bad Scooter with the epic Venmo that just came in. Thank you so much, Bad Scooter. We can do it live. I was thinking about just releasing it, but we can do a premiere with a video. Okay, we'll do a premiere. We'll do it, let's say 10 a.m. Eastern Standard Time tomorrow. We'll do a premiere. It's only about I think it's like 15 minutes long. So I don't like doing premieres for those that, when the video is that short, but you know what? You Venmo'd it, you asked. Let's do it. 10 a.m. tomorrow, I will release the road trip video as a premiere. So yeah, look for that. But yeah, thank you so much. Bad Scooter. Thank you. I just blanked. Thank you so much, Bad Scooter. Okay, let's go.
Next matter is the impound hearing of Carlson versus H&H Towing. I think I saw Dylan Carlson.
Okay, looks like we're not doing it at 10 a.m. How about we do it? Does yours start at 10, Sashina? My video is 15 minutes long. I'll start at 9:45 and just raid your channel. How about that? Can we compromise on that?
Logged in here. There we go. And then I see H&H Towing.
Yes, sir.
All right. And I did receive a motion from Wendy Carlson, the authorizing agent, for a continuance. But
she's actually present, Your Honor.
Yeah, I see you're logged in there. So is there still a request for a continuance?
I don't believe so. I think she's trying to queue in now.
Your Honor, Your Honor, I'm here. I'm 9 hours ahead, but I'm here.
Oh, you're calling in from elsewhere, huh?
From out of the country, yes.
Oh, okay, very good. Okay, then this is the challenge to the impound filed by Dylan Carlson. I'm just opening up my court file.
You know what I don't do enough? I don't make polls. I'm going to put a poll. And this is my question, because this is an honest question I have. Now, this is the male Karen, the Kevin, the Chad. I already forgot all the other names everyone said. But yeah, this is the guy who I was talking about. I want to know, is this his idea, or I'm guessing his wife is sitting next to him? People on the bottom part of the screen. So I'm going to pull a poll up. Is he the Karen, or is she the Karen and he's just doing what she says? I'm going to put the poll up, and I'm going to let this play, so we'll see at the end.
There we go. Okay, so Miss Carlson, can I start with you? And before you testify, let me have you raise your right hand and I'll swear you in. Do you swear that the testimony you give in this case will be the truth, the whole truth, and nothing but the truth?
I do.
All right, and so Ms. Carlson, can you identify yourself and then explain to the court the circumstances of the impound?
Wendy Carlson, we're the owner of the parking lot at Fishtail. And I called H&H Towing, which we're contracted with, on March 2nd, around 9:30, 9:45, to have Mr. Carlson's car towed out of the parking lot, as we have had several cars parking there in the parking lot, and it's a private lot.
All right, can you tell me where that lot is located?
515 Jefferson in downtown Olympia.
All right, thank you. All right, and is H&H your your impound company?
Yes, it is.
Okay, is that parking lot posted with signs?
We have recently installed, on February 16th, I believe, we installed signs at every entrance into the parking lot that shows that it's a private lot and has the H&H Towing right below it. And actually the posts are bright yellow to make sure that everybody sees that it's a private lot.
All right. And can you tell me again, if you haven't told me already, what was the date that the vehicle was impounded?
I believe March 2nd.
That's correct, Your Honor.
Okay, is there anything else, Ms. Carlson?
No.
All right, and then from H&H Towing, what's your name again, sir?
Jerry, Your Honor.
Okay. All right, and Jerry, can I have you raise your right hand, please? And do you swear the testimony you give in this case will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
All right, and then can you explain to me the circumstances of the impound at 515 Jefferson on March 2nd?
Yes, sir. So we received a telephone call from Miss Carlson, Wendy Carlson to be exact, approximately at 9:45 p.m., letting us know that there was a vehicle that needed to be impounded on the lot that was illegally parked. We dispatched a driver out to that location. Wendy signed the proper impounding forms for us, and we towed the vehicle according to the law with our signs posted the way they're supposed to be posted, and brought it back to our impound facility. And then I guess the vehicle was released that same evening from what I'm looking at here on my paperwork.
While he paused, Jerry's the tow truck. He either owns the tow truck company or he's the tow truck driver. I don't remember which one was which. I'm getting tired now. So yeah, hour 15 minutes, starting to turn into a pumpkin. Who says that? Sometimes I say my mouth goes faster than my brain, and then right when I say things out loud, I just who says this? All right, yeah, Jerry's not one of the two. Yeah, let's just go.
All right, and then what were the charges for the impound?
The towing charge was $342. There's an after-hours release fee of $127. Storage for $44.50, and then it came out to $513.50 in tax. No, excuse me, that was a subtotal. Tax was $48.78, which gave us a grand total of $562.28, sir.
All right, and are those the authorized?
Yeah, actually, no, Cinderella didn't say it. Her fairy godmother said that, not Cinderella. Right? I'm right on that. I think.
Posted rates?
Yes, sir.
Do any of those items vary from the authorized or posted rates?
No, they do not. It just depends on our storage, on how long a vehicle actually sits in our yard.
And at this particular vehicle, how long was it stored?
I'm trying to see when the release was actually done. It was impounded at 10:15 total. And it appears that Mr. Carlson signed our paperwork at approximately 10:45. From what I understand, I guess they possibly followed the tow truck over to the yard. So the vehicle was dropped in the yard. And then it was released to them just beyond that, sir.
So it was released the same day?
Yes, sir.
All right, thank you. All right, then I will hear from.
All right. You know, we heard logic. We heard logic and reason. Now we're about to hear whatever you want to call this. Let's go. It's about to go down.
Mr. Dylan Carlson. And Mr. Carlson, can you raise your right hand, please? And do you swear that the testimony that you give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes, sir, I do.
All right, go ahead, Mr. Carlson.
I'm joined here today by my wife, Brittany Junker Carlson, who is the driver of the vehicle on the date in question. I am the registered owner of the vehicle and the petitioner in this case. Also, just note for the record that there's no relation between our Carlson household and the household of Wendy Carlson. I am seeking to...
Please tell me you saw the look on the judge's face right there. He's like, why would you say that? why it doesn't matter. This is civil. This isn't criminal. We're not putting people in, in the witness box, can't even think of the word. Yeah, okay, thank you so much. You made your record. Let's go.
To request the court deem this impounding improper under the applicable RCW, both based upon the fees charged and numerous failures of the respondent and the impounder to follow applicable law, both on the city and state level. The first concern I have is that the fees charged to us are in excess of those fees on file with the Washington State Department of Licensing. The attached paperwork that I submitted to the court yesterday shows the public records request that we submitted to the Washington State Department of Licensing and the responsive paperwork they had provided. The fees on file with the Washington State Department of Licensing were last updated in approximately October 2021 and are substantially lower than the fees charged to us. That is in violation of RCW 4655.063 sub.1. Additionally, my public records requests public records indicate that Wendy Carlson is not the appropriate owner of 515 Jefferson Street, nor is she authorized to impound vehicles from that property. The paperwork, the impound notice signed by her and submitted as part of the tow truck company's evidence indicates that Wendy stated she was the owner of the property at 515 Jefferson. The public record shows that 515 Jefferson Street is owned by Fishtail Brew Pub. The adjacent property at 415 Fifth Avenue Southeast is owned by Dina Carlson, who may or may not be a relative of Wendy Carlson. In any case, the public record does not indicate that Wendy is the owner of a property at 515 Jefferson. Additionally, H&H Towing is not licensed as a business in the city of Olympia. Chapter 5.02 of the City of Olympia Municipal Code requires anyone conducting business within the city limits to maintain a valid City of Olympia business license endorsement. H&H Towing does not have such an endorsement and is in violation of the City of Olympia Municipal Code. Further, H&H Towing is not legally licensed as a towing operator in the City of Olympia. Chapter 5.72.020, apologies, of the Olympia Municipal Code requires that a tow truck operator must maintain a towing operator's base license issued by the City of Olympia. And H&H Towing does not have such a license, at least according.
Just wait. He's citing off laws that he did research on. I know. If he had a legit legal case, I would not have said that. But there's also a reason I didn't put Karen in the title or the thumbnail because, I don't know. This is one of those borderline ones that I just have this, my Karen radar is going off. Just wait. The tow truck driver, no, the owner of the lot is going to talk. I think that's the person who breaks the case wide open. But okay, let's keep going.
To the public records available from the Washington State Department of Revenue Business License Lookup Service. Further, the impounder inappropriately charged an additional hourly labor charge. RCW 46.55.063 sub.3 provides that an impounder may charge additional hourly rates after the first hour and charge to the nearest quarter hour. The paper trail shows that the vehicle was redeemed 59 minutes after the first billable hour shown on the receipt. And so all of the charges should have occurred within the first 60-minute window, and no additional hourly labor rate should be charged. And then finally, we believe that H&H Towing charged excessive fees for services not warranted and refused to accept payment for an incomplete tow. My wife, Brittany Youngquist Carlson, will be happy to testify that when she returned to the car on the night in question, the driver was in the middle of securing the vehicle, but had not yet secured the vehicle. The tow truck driver operator was in the middle of securing the vehicle and had not yet removed it from the property. She requested that he disconnect the car and that she could pay an appropriate hourly rate for the services previously rendered. This is commonly known as a drop fee or an incomplete tow in the towing operators industry. The driver of the tow truck company said that that was illegal and refused to charge for an incomplete tow. There is no law in the state. There is no state law or City of Olympia ordinance preventing an impounder from charging an incomplete tow. And it appears that this was either a misunderstanding of the tow truck driver at best, or a blatant lie at worst, in order to increase the fees charged to my household and to rack up the bill. This included an unnecessary storage fee of $44.50 and an additional hour of labor charge at $127 per hour. We've already expressed concern about that additional $127. RCW 46.55060 sub 6 requires that the accrual of storage fees cease immediately upon notification of an intent to redeem a vehicle outside of business hours. Because the vehicle had neither been impounded nor placed in storage at the time the vehicle operator made the request to immediately redeem the vehicle, it is not appropriate to charge a storage fee. And these fees are excessive and seemingly violate the legislative intent of the RCW, which the legislature finds that the use of a motor vehicle is often necessary for residents' livelihoods and families. The legislature finds it is important for the public to know what the charges and fees will be for the private impounds of cars and other vehicles parked on private property, and that those charges should be reasonable to ensure that the residents may retrieve impounded vehicles. The actions of H&H Towing caused unnecessary delay, financial hardship, and frustration to our household. For those reasons, we believe that the impounding was improper, the charges were improper, and both the court filing fee as well as all of the fees paid to H&H Towing should be returned to our household.
All right, I'm not gonna lie. I think I almost dozed off at the end there. It got really long. All right, so just wait. Let's go.
All right. And I'll start with any response from Ms. Carlson regarding Mr. Carlson's petition.
Yeah, my mom is the rightful owner and has owned that property for many, many years and has given me permission, as she's 84 years old, almost 85, and stage 4 cancer, and has given me permission to tow cars out of there. If you would like to see her on a Zoom call when I get home, she will be on camera to tell you that I have permission to tow cars out of there. The Carlsons have parked there for years, as they have stated on a social media app. They were at the Banff Film Festival and parked there and got towed. They have used it over and over and over again as free parking downtown, and they are angry that they got towed on that night because they've parked there for free for several years.
Boom. There you have it. You see the looks on their faces right now? They're like, oh no. How do they know that? Owner of the lot just happens to, this little app called, I'm just gonna say Facebook. I don't know what app they're using, but judging by, I'm gonna just guess Facebook. Let's just say that. Oh, we looked these people up and they've been bragging about free parking every time they go downtown. They've been bragging about it. They've been doing it for years. Oh, they did it on this film festival, and guess what? We were waiting for them, and we towed their asses. And you know what they did? They sued us because they were unhappy. That was the point that I made you wait through that entire video for. And to pause right now in their faces, they're like, oh shit. All right, let's go. I'm gonna end the poll now. I think everyone's spoken. There's still a couple minutes left, but I'll let it go for a minute.
All right.
And I believe that the towing contract states that the owner can give permission to someone to tow the property.
All right, I understand. And then let me go to you, Jerry, at H&H for any response from H&H as to Mr. Carlson's allegations regarding rates.
Sure. So the rates are set. I don't know exactly where he got those figures, but those are standard impound rates. Second of all, H&H Towing is licensed. We go through state patrol inspection every year, and we have to have a business license to operate in the city and the county under H&H Towing. So as far as not having a business license to be able to operate in the city and within the county, that is completely false. We do meet all those statutes. Also, I'm not quite understanding, he's saying our driver has to have a tow operator's license in the city of Olympia. There is no city of Olympia tow operator's license. I'm sure we could go to any other tow company and none of their towing operators have tow operator licenses to perform their duties within the city limits. So I don't feel that the impound was improperly done. We have the lot well marked. They do have private parking lot. Vehicles will be towed with our impound signs underneath of them. So the lot is clearly marked that it is a private lot. I don't think I have anything else to say on that matter.
All right, thank you, everybody. All right, I'm going to find that that Wendy Carlson is an authorized agent of the owner of the property at 515 Jefferson by virtue of her representation and her business practice to authorize impounds. The lot appears to be properly marked with signage. There's examples of that submitted in the record in the respondents' pleadings. They appear to identify the towing company, how to redeem a vehicle that's been impounded, and they appear to be prominently displayed, as was testified to, at all the entrances to the private lot. And further find that the authorized impound was properly conducted by H&H Towing, and that the fees charged were fees that are authorized and are not in excess of allowable rates.
Your Honor.
Therefore, I'll find that the tow was.
All right, this is what I am. I hit a wall. I hit a wall about 10 minutes ago while this dude was talking. You can hear him start to interrupt. Your Honor, Your Honor, Your Honor. This is hilarious. Like he can hear you, man. He's gonna finish his record and then he'll talk to you. Calm down. Calm down. All right, I'm gonna let this play out. There's about 2 minutes left of this video. You guys all have a great night. I will jump over to Discord for a couple minutes. I won't be there long as I'm already falling asleep, but I will hang out for a few minutes. You guys are all awesome. Again, look for the road trip court crawl video in the morning. Like I said, it's ready to go. I just need to hit that publish button. But you guys are all awesome. Thank you for the super chats. Thank you for the gift of memberships. Thank you for the Venmo. Bad Scooter, I appreciate it. Okay, you guys all have a great night. If I don't see you in Discord, I'll see you tomorrow. Until then, bye.
Was authorized and reasonable.
Your Honor.
Yeah, somebody has a question?
Yes, this is Dylan Carlson, the petitioner. I believe with regard to the fees charged, you are discounting the obligations of the towing impounder to post their fees and file them with the Washington State Department of Licensing. The RCW clearly requires that they must do so and provide due notice before changing those fees. While the fees they're charged are potentially up to the maximum allowable by law, the RCW does require that the towing operator file those fees regularly updated with the Department of Licensing. And the last time they did so was in 2001. The fees charged to our household are in excess of the fees on file with the Washington State Department of Licensing and are therefore impermissible under RCW 46.550637 sub 1.
All right, and I did hear you make that argument, but I've made my ruling and I've explained it, so that's the end of the matter for today.
Thank you, Your Honor.
All right. That'll conclude this case.